Do not put your kids on your deed. It could cost you thousands, and here's why. I'm Tracy Zimmer with Zimmer Law Firm, and I'm an estate planning attorney in Pennsylvania. So it sounds simple. You add your kid's name to the deed of your house, and then they automatically get it when you die, right? But what if I told you that this could potentially lead to lawsuits, tax penalties, and even losing your house entirely? This is a common question I get from a lot of people is, should I put my child on my house? So let's say, for example, your child's married. If they get divorced, potentially their ex could come out after your house, the house that you're still living in. You know, there's a lot of risks that people don't see coming, and we're going to go through that in this video today. So the one is loss of control. So the moment you add someone to the deed, you're no longer fully own your house. At that point, you're going to need to get their permission to sell or refinance the house. If they get into any sort of legal trouble or debt, your house is exposed. You know, it's an asset of that person as well. It's not just a convenience factor. It truly becomes that person's asset when you add them to your house. Divorce. Nobody wants to think about divorce, but what happens if your child gets divorced? Their spouse may claim part of the house in the divorce settlement. Even if your child doesn't want to fight over it, you know, the law might not give them a choice. That is an asset of your child at that point. Very similar vein, but let's say your child gets sued. So they either file for bankruptcy, they're in a car accident, there's some sort of lawsuit, they owe taxes, something like that. Their name's on the deed, so that part of that asset is theirs. Creditors could put a lien on your house. There's some issues with Medicaid potentially if they would get injured or anything like that. And the big one that I talk to people a lot as well is that you're going to lose a step up in your tax basis. So this is when it comes to capital gains. And this is like a hidden tax bomb. So let's say you bought your house 30 years ago and you paid $100,000 for it. So if you add your child to your deed, they get your original basis. So they get that $100,000 as their tax basis for what you paid for it when you bought it. And then let's say then you die and then they sell the house for $400,000. Their basis is $100,000. Sell the house for $400,000. So there's a $300,000 difference there. They're going to pay capital gains on the sale. And capital gains could be 15 to 18%. So counter to that, let's say you instead allow your child to inherit the property, you don't put their name on it. They get what's called a step up in tax basis at your death. So instead of that tax basis being $100,000, their tax basis then is $400,000, which is the sale price. So then they pay zero in capital gains. One reason people come to me is that they want to avoid Pennsylvania inheritance tax. Well, this is a big conversation I have with clients because you're avoiding the 4.5% Pennsylvania inheritance tax to then pay more in capital gains tax. So a lot of times it is worth it to inherit it, pay the 4.5% at your death, and then avoid the capital gains tax. Now, what are some alternatives then to putting your child's name on your deed? So one thing is you can create an estate plan with an attorney like myself and put the house into a revocable living trust. So with the revocable living trust, it avoids probate, so it keeps things out of the courts, but then you control where it goes after you're gone, but then you also control it while you're alive. So you don't run into the creditor issues, the divorce issues, and then you get to preserve that step up in tax basis as well. And then there's another option is you can put it into an asset protection trust. That will help protect from Medicaid issues down the road. So if you are concerned about long-term care, going into a nursing home, you can put money in or put your house into that type of trust to be able to protect against it. But there are very, very limited circumstances where it makes sense to put your child on the deed. And I'd say 9 times out of 10, that is not my recommendation. To me, it feels like an easy solution for clients, but it can become a very, very expensive mistake. So if you are considering this, I would highly recommend that you talk to an estate planning attorney like myself to really go through what your options are and make sure you understand the pros and cons to everything. At Zimmer Law Firm, you can book a free consultation. Link is below. And I'd love for you to subscribe if you want to hear more tips about protecting your family, your assets, and your peace of mind.